From the college by the lake, meeting the personalities and discussing the issues that affect all of Coeur d'Alene and the inland Northwest. We are the North Idaho College Public Forum. And now here's your moderator, political scientist Tony Stewart.
Welcome to our program today. It is a pleasure to welcome a friend to the North Idaho College Public Forum, Irene Green. Ms. Green has been very involved with our lecture series at North Idaho College. She's attended over 20 years now those lectures and participated and asked a lot of questions, and it's her first time to be on our program, and it's way overdue. And we have a good reason for having her, other than the fact that she is so committed and interested in the issues that we've pursued over the years. Irene Green is finishing, as the committee comes to an end, serving as chair of the Coeur d'Alene City's Mayor's Committee that was entitled the Bi-Centennial Committee for the United States Constitution. Mayor Ray Stone appointed her to that committee some years ago, and she has worked throughout that process as we celebrated 200 years of the Constitution in North Idaho. But she also is the past president of the local chapter of Pro-America, which is another organization that's interested in constitutional issues. And as you know, for you who are viewing the program today, that on December the 15th, 1791, the Bill of Rights to the U.S. Constitution were added, and on that date we will be celebrating 200 years of the Bill of Rights, as we did earlier in 1987, celebrate 200 years of the Constitution. So I've asked Irene to come by today and to join with me in talking about the history of the Bill of Rights and some of the important issues that were found there. And I told her before the program that she and I today would come here as friends and advocates of the Bill of Rights as we discussed that important subject. So Irene, welcome to the program. I'm very happy to have you here.
Thank you. It's a real pleasure to be here. I've been looking forward to it.
Well, thank you. I know that you are also an educator. You taught school for 20 years. And
yes, I taught in Spokane Valley.
Oh, very much. So you're back home today.
18 years in North Pines Junior High.
Well, very good. And from all of that, you have certainly researched the Constitution. I know you've, as I've indicated in the introduction, been on these committees and studied, and you've brought people along with others on your committee to North Idaho, and recently a professor was in to play the role of Thomas Jefferson, and during that program talked a lot about the Bill of Rights. Would you start with the question, or responding to the question, that when the Constitution was drafted in 1787 in Philadelphia, submitted to the states at that time for ratification, there was a real battle between the Federalists and Anti-Federalists. Would you tell us what that was and how it brought about the proposal of the Bill of Rights?
Okay, well, there really was a struggle because, Thomas Jefferson, who's the author of the Declaration of Independence, was a minister to France. And probably if he had been one of the delegates to the Constitution Convention, they never would have passed it without a Bill of Rights. But then when they sent the Constitution for ratification, the big disagreement was because it didn't have a Bill of Rights. And so, I don't know how much you want at this point, but anyway,
I guess I would interject to say that
okay.
When it went to the states and the Federalists were pushing for its adoption, the states at the state constitutional conventions, and people were about to vote on it, it wasn't going to pass, was it, Irene, if they did not agree to the Anti-Federalist proposal?
That's right, and it passed in the states where it was ratified. It was ratified by a very, very close vote. And of course, James Madison was against the Bill of Rights because he didn't think it was necessary. But he and Thomas Jefferson kept up a correspondence while Jefferson was minister to France. And I have read those, and they're really interesting letters, because Madison, and also in the Federalist Papers, said it absolutely wasn't necessary, that the government couldn't do one single thing unless it was enumerated in the Constitution. I thought, oh, he ought to be here now.
Such things as the General Welfare Clause and all those?
Yes, right, General Welfare Clause and so many other things. But anyway, the two pivotal states were New York and Virginia, and everybody would, all the important people who were at the Constitution, like George Mason, I think it was, who said, I would rather have my right hand cut off than sign a Constitution without a Bill of Rights. And there's a lot more to it. I don't know.
Yeah, well, we'll go into that.
Okay.
Virginia was a really interesting state in this whole process because with Mr. Mason and Mr. Jefferson and others, they had a real understanding and appreciation of the need of Bill of Rights. And of course, some of our viewers who have not had history, or even those who have, may appreciate the point that we're trying to make, and that is that the Virginia Bill of Rights was really a forerunner to the Bill of Rights.
Oh, yes.
So we owe a lot to Virginia and the leaders in Virginia, do we not?
And George Mason.
Yes.
He was the leader of it. 1776, as a matter of fact, the Virginia Bill of Rights was.
So I want to go back to, we want to go into detail on this because your background is very thorough. Thomas Jefferson, in his letters to Mr. Madison, really was arguing for the Bill of Rights. And do you think he had a great influence in convincing Mr. Madison that they better agree to them and introduce them in the Congress if the Constitution was ratified?
Yes, I do. However, when Madison ran for Congress, for the first Congress which convened in 1789, and when he did that, he had to promise his constituents that there would be a Bill of Rights, and so he had a selfish motive also. He wanted to get elected.
So, Irene, are we saying that in history we've given a lot of credit to James Madison for the introduction of the Bill of Rights in the Congress, and they were proposed and sent to the states and were ratified, as we indicated? The final ratification of the states, enough to make them part of the Constitution, was December the 15th, 1791. You're saying he doesn't deserve as much credit, that the pressure from Jefferson and the Anti-Federalists and the Constitution would not be ratified. He didn't have much of an option, is that correct?
No, that's my opinion, from what I've read.
Okay. Do you have any knowledge from all the work that you've done on this, that at the time that this correspondence was going on between Jefferson and Madison, what was Mr. Mason doing? Was he also in contact with Madison and trying
Well, he was in the Virginia House of Delegates, I think. And of course, he had said that he'd rather have his right hand cut off than sign a Constitution without the Bill of Rights. And since he was so influential, another influential person who didn't have anything to do with the Constitutional Convention was Patrick Henry, because that's one of the Idaho Humanities Council, sponsored him too.
But Mr. Mason, by saying those kind of things and rallying the people in Virginia, could he not also get some of the credit that Madison recognized the sentiment of the people that was being, since Jefferson was out of the country, Mr. Mason probably was doing more to convince the people in Virginia that affected him, and then as he ran for office, that is Mr. Madison. So it was like public opinion of the day.
Yes, I think so. And had Madison not agreed to a Bill of Rights, he might not have been elected. So I think it was sort of selfish on his part. But I think more credit actually should be given to George Mason, because Madison did the handling of it when it got into Congress.
Okay. It gets to Congress. They obviously at that point didn't have it all laid out what would be in it, so they even debated, did they not, what else should be in the Bill of Rights?
Well, an interesting thing that I have found out is that George Washington suggested that the states, if they were so dissatisfied with the Constitution, that they submit ideas for amendments. And you know how many ideas they submitted? 189. So they really were happy with the Constitution, weren't they? Anyway, Madison reduced those to 17, and the Congress passed 12. And I hope you'll ask me a question about the first two that weren't ratified.
Well, I'm going to do that right now. In fact, Irene, it's very interesting that, again, some viewers might not be aware that when they went to the states, it wasn't 10 amendments, but it was 12. But the states had the right to ratify those individually. They could, any one or more of the 12. And so the end result was that 10 of the 12 were ratified, became the first 10 amendments. And in fact, I have in my office the 12 that were given to me. They were burned into a plaque and presented to me some years ago by some friends. And I've often talked to students about that. And so would you share with the viewers what were in the two amendments that did not become a part of the Constitution?
I think it's really interesting. The first one had to do with the apportionment of representatives according to population, which is what we have now. And so you could see that was more or less irrelevant to a Bill of Rights. But the second one is really interesting, because that one said that Congress could not raise their salaries until there was an intervening election of the House of Representatives. And so if we had that now, they wouldn't have been able to get $125,000 a year.
So, in other words, they could raise the salary, but wouldn't go into effect until the next
they could raise it, but it wouldn't go into effect until after an intervening election. That's correct.
So there would be a delay process. In other words, it wouldn't have prevented increase in salaries over a period of time, but would have
Yes.
been a time period in between.
Anyway, they would have to face the electorate, the representatives, before they did that.
Now, with that historical background, which you've been very articulate in presenting, we're now down to the ratification, which took place on December the 15th. Would you kind of like to take us through the states and how that went when the amendments were submitted and became a reality on that date?
Well, Delaware, of course, was the very first state. You know, they have it, this motto, the first state or something like that. And then there was really quite a struggle. And Virginia being such a key state, and so New Hampshire was the 9th state, though, that ratified it on June the 21st, 1788. And that's when it became legal. You know, that's when it became the supreme law of the land. That's the Constitution.
Yes.
But then Virginia ratified it in 1788.
And then after the Constitution was ratified, of course, and I was asking concerning the Bill of Rights, once they were through the first Congress after the Constitution was in place.
September 25th, 1789 is when they went to the states.
Right, and that's what I was speaking to, is that question. And once they went to the states, tell us the process of the and the order of the ratification of the Bill of Rights.
I don't really know who was the first state to ratify the Bill of Rights. I just know the last state. I've never done any.
Well, share with the viewers the last
That
state.
was Virginia.
Yes.
The key state. On December 15, 1791.
Did they intentionally hold off, although they were so enthusiastic, or a lot of their leaders were for the Bill of Rights, did they intentionally want to be the state that would bring it over and cause it to be ratified?
You know, that's an interesting comment.
So I've read, and I haven't seen that in the literature that
yes,
I've read.
That's I don't know that I've read it either. That's certainly a possibility that since they were such a key state, and you know, we have about 5 presidents are from Virginia. And that's a very definite possibility, I think.
Well, let's move into a discussion of some of the content of the Bill of Rights and how you view their importance. First of all, if we go back and look at the 7 articles of the U.S. Constitution, and I've looked at those so many times in teaching in the field, I oftentimes tell my students as I look through the original document, I find mostly provisions that deal with what government can do, like Article 1, Section 8 lists all the powers of Congress, and there's a long list of things that they can do. Some of them are very specific and some are very general. But so I look for what I would call constitutional rights of individual. I find basically 5 such rights. There are certainly areas where sections, even in Article 1, it says there's certain things that the Congress cannot do and states cannot do. But I'm just speaking of when you look at things that are very directly placed toward the individual, such as that individuals in the original Constitution have the right to writ of habeas corpus, or no bills of attainder, no ex post facto laws, or the right to jury trial in federal court. They're very limited. And then when you get into Amendment number 1 and go through 1 through 10, some of those are longer than others, but they have a long list of very short phrases of rights.
Yes.
And so let's start with the First Amendment. Tell us your views about the First Amendment. And one can just list what the rights are: free speech and free press and religious freedom and no establishment clause, which many people call separate church state, the right to peaceably assemble and petition your government for grievances. It's a short paragraph, but a lot of rights, isn't it?
Yes, and one that's probably causing the most problems.
What do you mean by that?
Well, particularly the freedom of religion, and Congress shall be prohibited from interfering with the free exercise thereof. To me, it seems as if there's a dichotomy in view of the fact that teachers can't have Bibles on their desks. I mean, I think that's been ruled in a case in Colorado. And it seems as if, as long to me, that if the government is not really sponsoring it, that's and then they interfere with it, there's a dichotomy there with the free exercise of religion and then interpreting it as government sponsored, which would violate the separation of church and state philosophy.
So you're indicating that there's 2 clauses there instead of 1, and
Yes.
one of them deals with the role of the state and what the state cannot do. But I hear you saying that where one cuts that off, where one draws the line, is very difficult.
Very difficult.
The difference between if you're reading the Bible or having prayers, versus where an individual a teacher, for example, might have their own Bible or whatever there.
Yes.
Where does it become an official state action, and when is it the choice of the individual to have
That's what
something
I think
nearby?
is really a complex problem.
It is complex.
Yes.
Is it, Irene, is that more difficult to decide for the court than the second section where it deals with when the states, it's not a question of the state, it's a question of individuals that are out in society exercising their religious beliefs. Maybe they're going like house to house and with their religious literature. I know there was a case out of Connecticut many years ago where there was an attempt by law to deny religious organizations to go house to house without a permit from the state. Do you find that easier to deal with clearly what the rights of individuals are?
I would be very much against that.
Yes.
Prohibiting individuals, because we should, if you have the free exercise, as long as you don't hit somebody over the head and try to force them.
You're saying it's between the individuals involved and the states stay out of it. And it's a voluntary thing. If the individual wants to hear it, fine. If they don't, then you would go on to someone else.
Yeah. One of the things that I think the Bill of Rights is a prohibitions more than rights, really. If you analyze it, they're prohibitions, things that the government cannot do also.
And by denying the government the right to intervene, then that leaves the individual free to make the decision for themselves.
Absolutely, and I think that is really a very important item, if you want freedom.
Mm-hmm. Now that you've looked at this and you've helped celebrate this in a lot of different meetings and so forth, I mean, this may be a very difficult question to deal with, but as you look down through them, I know they're all important, but is there one or two that come to your mind that you find most essential or those that you like best?
Well, of course, I really like the first one, and I think the fifth one also is very important for rights of the individual if you happen to be involved in a crime. I think many people now, though, think that the criminals have the rights instead of the citizens.
So again, when you're addressing such issues as due process,
yes.
When an individual is accused of a crime, isn't it clear that both from the language of the Bill of Rights that's interpreted over 200 years that, although it doesn't say these words in the Bill of Rights, we have created a judicial system where it's very important to us under due process that the individual is presumed innocent until proven guilty, where in a court of law. And in that happening, there are certain safeguards up to that point. But I hear you saying that sometimes it's not real easy to determine what the role of the police is.
Very difficult. And I'm glad I'm not a judge and have to make a decision in some of the cases.
Mm-hmm. In relation to the Bill of Rights, as you look through them, they're very specific. We've talked about the First Amendment, but you have issues such as the right to a jury trial in major criminal cases, right to a public trial. And of course, we've had that interpreted about you can't have disorder and people yelling and screaming in the courtroom, but right to witnesses and to cross-examine witnesses that are adverse to your case. We also talk a lot about the whole issue of due process and what is cruel and unusual punishment and what is legitimate and not legitimate in search and seizures. A lot of those deal with two different areas, I see it. I want to identify those and get you to react to them. It seems to me that the Bill of Rights has a number of provisions that don't deal with the accused or criminal action. They just deal with citizens in society, is right to free speech or free press or right to assemble. But then we get these others, like we've been identifying in the Fifth Amendment and the Fourth Amendment and so forth, that they're directed very much at trials and what happens to the accused. Do you think that the Founding Fathers were very aware, and you've identified that they sent an awful lot to the Congress and it was narrowed down to these, but do you think they were thinking in the terms that there are almost two major categories here of how people are living their daily lives and the freedoms they have, and then also, just for those who happen to be accused, the list of rights that they have?
Well, that perhaps entered into it. One thing about the Founding Fathers, they probably never anticipated that Americans would not exercise their rights responsibly, because it would be difficult for them to visualize anything else when they valued freedom so highly.
When you look at that, then you come on down to the Ninth Amendment. Of course, the Eighth Amendment, we talk about cruel and unusual punishment, and that leaves a lot of room for discussion and interpretation too. But in the Ninth Amendment, we can't find specifically in language what's there. However, it indicates, of course, I always paraphrase it this way to indicate that the Founding Fathers were saying, we tried in 1 through 8 to list some very precious rights that you have. But we had this long list, we didn't put everything in, or we might have tried and forgotten something. So the Ninth Amendment does recognize the fact that we might not be perfect, we might not be all-inclusive.
It's a good thing we have that.
Isn't that, though?
I think it's very, very fine that we have that. By the way, that's the only amendment that was not in state constitutions, which were written between 1776 and 1787. So the states really had a lot to do with the federal government getting those rights.
Yes. So what you're saying is that prior to the adoption of the Bill of Rights in the U.S. Constitution, that state constitutions, through the state leaders, had attempted to pretend, at least, that they had exhausted the list, that is, that they were all in there, and that the U.S. Constitution was the first to put in, well, we may have forgotten things, and they were retained by the people under the Ninth Amendment.
Right.
When you look at state constitutions today and their Bill of Rights, you will find that provision in there. So in that case, there's kind of reversal, isn't there, here, that the Congress and the national government was borrowing from the state of Virginia, for example, a lot of the things for the Bill of Rights except the Ninth Amendment. And then once that's in place, then the reverse took place, and the state says, well, we better follow the path of the U.S. Constitution and place that in there.
I'm sure that is true.
In relation to that, this is something else that I often ask. Since it's not specific, would you mind sharing with the viewers something that you think is in the Ninth Amendment that was left out of the other amendments?
Privacy.
Okay. Very important, isn't it?
Yes. And I was thinking of that in the recent hearings.
Mm-hmm. And the U.S. Supreme Court has even recognized that they've not talked a lot about the Ninth Amendment, but they've used the word privacy in relation to the Ninth Amendment.
And that word is not in the Constitution. So
anywhere?
No, not anywhere. So it definitely comes from that Ninth Amendment. The prohibitions, the rights that are not enumerated are in there anyway, even though it doesn't say so.
Irene, do you think in 1991 when we were doing this program, and you look back all the way to 1791, that if the Founding Fathers were alive today, they might be more appreciative of that and even place the word in there, because with high tech that we have with computers and satellites and all these things, that privacy could be invaded easier now than in those days?
Oh, it certainly can be. That is for sure.
Mm-hmm. And by interpreting it that way today, as long as you have courts that will do so, it'll be protected. But would you advocate maybe even writing it out in specific terms in the Constitution so that a court couldn't even have any leeway in saying it does or does not?
Well, I don't particularly go for being too specific, because then if you're too specific, we wouldn't have a living Constitution, which has changed with the needs, of the people. So I think, although in my opinion there are some things that never should be changed by popular vote.
Uh-huh. That's a really good point. You're suggesting that there's some things that the majority can decide, such as who serves in office. But you're suggesting that there's some things you never take to a vote because they're a right that every human being has.
Absolutely. I have unalienable rights, and government or nobody else, and they might take them from me, but they're not entitled to.
Aren't you better off than you were or anyone else if the Constitution wasn't there? Because you and I could contend, in fact I have, contend that the human being is born with inalienable rights if there even wasn't a Constitution. The government's created to protect, as Jefferson said.
Yes.
Government is created to protect the natural rights of individuals, and when it ceases to do that, it would no longer be legitimate. And fortunately, we wrote a document to elaborate upon that. But since that would be an inalienable right in your opinion, any of those that are in the Constitution specifically are in the Ninth Amendment, inalienable rights, that if any time in this country someone proposed to vote on those, that even voting on them would not be a legitimate process.
No, it wouldn't be, and I'd probably land in jail,
For civil disobedience.
Yes.
Yes. Well, you're not alone in that, and there's been great scholars of the Constitution and of natural law And people in jurisprudence have argued that throughout the centuries, and great political philosophers, that in fact that's where that came from, is from many great political philosophers. And I think that's why maybe Georgia Mason and others appreciate the fact that we should write it down.
They were very well read, the founding fathers, that's one thing. And they had read histories of governments and countries, and they really knew whereof they were speaking.
You were involved with others in bringing a Dr. Jenkinson to North Idaho recently to deal with the works of Thomas Jefferson, and we've been talking some about him in relation to the Bill of Rights, and I think it's appropriate on this birthday that's coming up to give some attention to Jefferson. Take a minute with our viewers to give your opinion of Thomas Jefferson and what impressed you most about him and his works.
Well, of course, what really impressed me was his Declaration of Independence, because I think that there might not have been a Bill of Rights had it not been for the great philosophy in the Declaration of Independence. And I don't know whether you're aware of this, but Victor Havel, is that how you pronounce his name, President of Czechoslovakia, said that he read and reread Thomas Jefferson when he was imprisoned for political crimes in communist Czechoslovakia. So, I think that the Declaration of Independence has inspired millions of people throughout the world.
Not just the United States.
Not just the United States. In Africa, for example, one time I heard when they were breaking away from colonial European rule, and I think it was Zimbabwe. Well, no, that was Rhodesia. I can't remember, another country. And this black man was on TV, and he quoted the Declaration of Independence. It was amazing, You're way across the world.
I can testify to that. I was talking, and in fact, I was having dinner with an individual from South Africa who now lived in the United States and had been involved with some of the, in fact, her father had been very involved with the struggle for independence for the black population in South Africa. And she said that nothing had influenced their movement as much as the Declaration of Independence and what they have, their Bill of Freedoms. And she gave me a copy, and you could find within that this great influence from the Declaration of Independence. So I hear you saying that even though the Declaration of Independence was never law, it wasn't a constitution, it was and is a political creed.
It's ideals. It sets up the ideals for which we can strive.
And it's a political creed. It's been borrowed by those who seek freedom around the world. It planted ideas that live on.
Right.
And it also reminds us, does it not, if there is violation within our Bill of Rights, that we can go back and say that we promised that we would do these kind of things, these principles.
So that's why Jefferson is so important.
I have to interrupt. Time is up. I can't believe it.
Oh,
Thank you very much,
either.
Irene, for being with us, and appreciate your time.
Thank you very much for the opportunity.
Ladies and gentlemen, I hope you've enjoyed our program, and please join us again next week at this same time when we will discuss an important subject. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum is videotaped live by Telemedia Services on the campus of North Idaho College for viewing at this more appropriate time. We invite you to catch the North Idaho College Public Forum the same time next week on this television station.